Briefly speaking, with me Tarun Nangia, Justice Tejas Karia has not minced words and put it very succinctly that fees paid to mediators should be commensurate with the work that they put in. It should be linked also to the size of disputes, of course, with a cap, but it should be in a way that the mediation bar develops, that people actually take this seriously. Like we know that in America, 95 or up to 95% of disputes indeed get settled via mediation. In India, the number is barely a few percent or even less. But why would people go in for mediation if they can't earn a livelihood out of it? Secondly, if commercial disputes, here we are today focusing on commercial disputes, and if commercial disputes worth tens and hundreds of crores are settled in a matter of a week, uh, there's huge money anyways saved on litigation. So if a little fees is given to mediators, it would go a long way in ensuring that industry gets service and dispute resolution much before litigation. And that's why what Justice Tejas Karia has said is indeed going to have a far-reaching import. And I think it will take the form of a movement in near future. Uh, I'm not the one to speak. I have a very eminent panel. I want to welcome Justice Ajay Rastogi. Thank you so much, sir, for sharing time with us today on this important issue on a weekend. And we look forward to your comments. I have with me Advocate Nikhil Rodgi joining me. Good to see you, Nikhil. Thank you for your time. Advocate Vivek Jain joins us on this subject. He has some strong views on the subject of mediation, dispute resolution. Karthik Seth, who does a lot of arbitrations of late that I hear from him, and he also will pitch in on his views on the topic of mediation. At the outset, let me request Justice Ajay Rastogi to give the opening line, and then we will start with the other panelists. Over to you, Justice Rastogi.
I'm so thankful for giving me this opportunity. And I tell you one thing, I myself is a trained mediator. I did my training in 2010 and was the first in charge of mediation in my state of Rajasthan, attached to the Legal Service Authority. So mediation at that point of time was not institutionalized. And people were doing pro bono. There were no rules and regulations for mediation at that time. And we followed certain guidelines laid down by the Delhi Mediation Center of 2005. Now, I have gone through this Act of 2023 also. If you have the Mediation Bill of 2023. At least I would like my all friends here who are sharing this link today with me. Let us first examine what are the qualifications for becoming a mediator. Who can be a mediator? Under the Act of 23, it's completely, which I have not been able to gather anywhere. Who is qualified mediator? They say you are attached to a council, you are attached to some institute, but the problem is who can be a mediator for the purpose of mediating these commercial disputes? First thing. Second, if you have institutionalized mediation, it has to be incorporated in the agreement. As on today, when we are discussing the issue, it will take another 5 years down the line. If the mediation is incorporated in the agreement, and 5 years down the line, when the dispute will arise, then the question will arise how the mediation disputes are to be resolved. Third, when you talk about the remuneration payable to mediators, the cost factor. Under the Act of 23, they say it will be prescribed, Section 25. But I don't find anywhere the government has prescribed any fee payable to mediators. The only fact comes across with me if Section 25 is let the parties may agree. If the party themselves agree, no schedule is required. But to my knowledge and my view is, it should be prescribed under the clause itself. Either you may adopt for the time being as long as the government not prescribe the fee under their prescribed schedule for arbitration. Let us adopt some institutional fee prescribed. Let us go to either IICA, go to DIAC, go to four schedule, which I always say to be amended by the time because 2015, but it has to be prescribed. You can't leave it to the parties. You can't leave it to the mediator to negotiate with the parties and arrive to a conclusion that what should be the fee payable by the parties. If you start doing this thing with the negotiation of the parties, that will be, to my understanding, will be very damaging in getting this institution established. If this institution has to flourish in our country, if this institution has to function, this institution has to create credibility among the people at large, particularly in the commercial sector. Fee has to be prescribed, to be monitored, and only that fee, what the parties say, is not acceptable. So my only request is there should be a prescribed fee by the Council, Medical Council of India, or by any other authority the government mandates. And until that formula come forward, let us adopt some prescribed fee by any institute running the arbitration centers.
Okay, point very well taken, and good that you brought forth that point on fees. Uh, Karthik said I was discussing with you on arbitration the other day, and you in fact brought forth the point that arbitration is thriving, but mediation nobody discusses. And I'm very specific here on commercial disputes. Uh, what would you sort of like to say in terms of what Justice Rastogi had said, and if you have a view on what Justice Tejas Karia said?
Yeah. First of all, thank you, Tarun, for having me among this esteemed panel. I completely concur with what Justice Ajay Rastogi has just now mentioned with regard to a prescribed fee schedule. And since you mentioned what we were discussing about the other day, we also spoke about how there's a Schedule 4, which is prescribed under the Arbitration Conciliation Act. In the same manner, what fell from Justice Rastogi on this particular point, we can have a similar way of a prescribed fee schedule. And more so ever, when Justice Tejas Karia pointed out, I remember reading it from what you posted, saying that he's saying that there are air hostesses, doctors, engineers who are very well trained in mediation. So, as Justice Rastogi clearly pointed out, there's a particular role of a mediator. It does not need to be a specifically qualified. Sorry. Am I audible? Yeah.
You're audible. Yes, please go on.
So it was very specifically said at that particular point of time that there's a specific role for a mediator, and they need not be only specifically who are lawyers or who have done a law degree per se. We have many in the field. In fact, I know someone who's a retired IPS officer who have just recently done a mediation course and really looking forward to it because, see, more so ever because now he's like out of like his proper job which he was doing as an IPS officer. He's really looking forward to sharing his experience as an IPS officer and dealing with different kind of say all kinds of cases as in his role. So I personally feel that what Justice Rastogi said and what fell from Justice Karia, because of which we are starting this discussion. Once we lay down a particular fee schedule, once we give them the incentive to go ahead and uh, probably do something in a particular manner, which is lucrative, and at the same time they give back to the society, it will help in the larger scheme of things.
Thank you for that opening comment. I'll go to Advocate Nikhil Rohati for his opening comment.
Hi, Tarun.
Hi.
Thank you so much for inviting me on this esteemed panel with Honorable Justice Rastogi and my dear friends Vivek and Karthik. Now, I have a couple of points to make. Namely that considering we're dealing mainly with commercial cases for the purpose of this discussion, I think we must make the distinction between institutional mediation and private mediation. Now, in my view, it is for institutional mediation that, as Justice Rastogi said very rightly, that there should be a fixed schedule of fees. For private mediators, I believe there should be no schedule of fees. That should not be regulated. Because, in my opinion, that will be akin to fixing a fee schedule for individual lawyers, such as myself. Therefore, that's the first point. Now, within institutional mediation, there should definitely be something like the fourth schedule. I don't think anyone can disagree that there should be a fixed mediation. The only question is, on what basis should it be fixed? Now, in the course of my research, I came across a few institutes that act as mediation service providers. This is a concept brought about by the Mediation Act of 2023, which says that similar to the Arbitration Act, where you have private arbitration centers, uh, in addition to the ones open which are annexed to courts, they have their own rules, they have their own procedure, they have their own schedule of fees. Similarly, under the Mediation Act, mediation service providers have been allowed to do so. Now, some of them, I'll give you an example. Some of them have an hourly rate, such as the Indian Dispute Resolution Center, IDRC, that has an hourly rate, which says it shall be as decided by the mediator, but not more than 30,000 per hour. There are others such as the IAMC Hyderabad, where it's per session. There's the White Code Mediation Center, where it's based on the quantum of claim. So there are different ways to do it, hourly or as per the claim. Uh, but what's important is that there should be, in my view, now, we all know that for legal cases, lawyers are not allowed to charge a success fee. They are not allowed to charge a success fee because that is considered to be champerty, which is not allowed by the Advocates Act. But I believe that for the purpose of mediation, it should be allowed. There should be an incentive to the mediator of a success fee at the end. It could be a fixed sum. It could be according to the size of the dispute. Say you take 2% of the dispute. Because we must understand that mediation, unlike arbitration, if mediation fails, then you still have to go to, say, arbitration in a given case. Then you go to the court, start with Section 34, Section 37, then Supreme Court. So I believe parties should be allowed that option of maybe not having to pay a penny for mediation if it fails. And I know that's an extreme view, but that is something that should be considered. The other thing is that yes, so maybe there should be a percentage basis, maybe a success fee, and the mediation council needs to be set up immediately. In March 2025, Mr. Megwal, who is the MOS for law, he made a statement that they're going to set it up soon, because that is the council which, as per the act, is going to set down all the standards, decide fees, decide the schedule, etc., etc. So that needs to be done right away. And yeah, those are my opening comments.
Thank you, Advocate Nikhil Rodgi, for that well-researched answer. You gave us a lot of points to ponder upon. I'll go to Advocate Vivek Jain. Mr. Jain, you're a serial litigator, and given that we've discussed on this about why dispute resolution can be faster with mediation, how would you opine on this topic?
Well, Tarun, thank you firstly to invite me in this STEAM panel. Justice Rastogi is there, Nikhil and Karthik. So I think, Tarun, what we are actually talking about is actually a shift from voluntarism to professionalism. Because what used to happen and what generally happens is that you volunteer to become a mediator generally.
Yes.
Like the experienced lawyers, retired judges, you actually volunteer. You don't get anything out of it. So basically, from being volunteering to become a mediator, there has to be a professional avenue to become a mediator. Now, I'll just give you an example. Like I was just reading up on this. Delhi government actually in 2023, I was reading a news. They gave a honorarium of 5,000 rupees per case to a mediator who succeeds in a mediation. So Nikhil was talking about success fees. There is already a success fees because you don't get even that honorarium if you don't succeed. Now, suppose there is a matter of worth, let's say about 5 crores, 10 crores, even 1 crore. And if the success fees is 5,000, what would happen? Now, its effect is twofold. Firstly, there will be, I won't say non-seriousness. There would be non-seriousness as far as the parties are concerned. Because anything which they get for free, they would not take it seriously. Secondly, if there is no professionalism and there is no success fees, for a 5,000 rupees success fees, an experienced lawyer would not leave his case and a retired judge would not leave his arbitration. So therefore, it leads to a situation where your reference rates would also go down, reference to mediation, and your success rates also go down. So it's a double whammy. So therefore, according to me, this is it's a bullseye that a mediator fees has to be hiked. It needs to be it needs to be managed professionally. And I completely agree with Justice Rastogi and Mr. Rodki and Karthik that it needs to be institutionalized. And I obviously don't disagree that there has to be a schedule for which actually categorize. And it is my view that you should not only make it contingent to success, but you should have a percentage to it. If you settle a dispute of say 1,000 crores, why shouldn't a mediator be entitled to at least a fees of 5 crores?
Yes.
Because ultimately, the parties would have litigated for 10 years down the line and would have paid so much to the lawyers and and the court fees also.
Yes.
So it is not only cost effective, but it also gives a lot of incentive to the concept and the ecosystem of mediation itself. So therefore, I completely agree with what Justice Karia had said and what my esteemed panel is saying. And these are my comments.
Thank you for that in a sense, insight that you gave us on this topic. Senior Advocate Mukul Rohgi said some time back that the judicial system is creaking under the burden of 6 crore cases. And it couldn't be more than true, because even in Delhi, High Court matters may not reach, given how many cases a judge has to hear. Other high courts are a different story altogether. In some high courts, it's much more than Delhi High Court. And mediation only take off the burden of our courts. Given that as a fact, Justice Rastogi, I want to ask you, the idea that Justice Tejas Karia has propounded, that the fee should be commensurate to the dispute size, maybe a percentage, maybe a fixed amount, that some formula used to derive. If for commercial disputes, do you think if we move quickly on this, the courts can be saved from the burden? And given the appointment process of judges is also very slow in India, this seems to be the only solution as of now.
I'll tell you only one fact which has to be always kept in mind. When 89 was incorporated in the CPC, Section 89 in 2002, with various alternative mechanisms, the concept behind it was not to reduce pendency in courts. And I tell you with my experience, all these alternative mechanisms, even if are being utilized by the consumer or in a commercial dispute or a family dispute to its optimum, you will not find reduction of cases in courts. When I came to Supreme Court, the pendency in the Supreme Court was 64,000. And when I left Supreme Court, it was 79,000. Now, if you see Supreme Court, it is 86 or 87,000.
So it's increased.
And Supreme Court is working with its full strength throughout, or 1 or 2 days. So, we are not able to find out any solution. So, merely filling vacancy is not to commensurate with the pendency of court cases. The concept of arbitration or conciliation or mediation is not this to reduce pendency in court. The concept behind is that parties sit together, find out a solution, restore their relations. Animosity created between them can be resolved. Either it is a family, either it is a neighbor, either it is in a commercial dispute, the partners who are fighting for their commercial causes for years and years together, their business are being ruined. They have completely stopped taking any further recourse or business transaction between them. Suppose today I am in arbitration today with one of my consumers. If I go to arbitration, I'll settle my issue and my business relations will continue. But if I go to court, in a civil court or other courts, and it takes 20 years down the line in resolving my commercial dispute, my business relations with that party is completely spoiled for all times to come. I will never come to any commercial relations with them. The object is only to restore your relations, to maintain harmony between the litigants, between the parties, to continue with relations for times to come, whether it is your neighbor, your brother, your family, your partner. So don't tear up the relations, restore the relations. And that is possible only with this mediation or arbitration as the case may be. Now tell me one thing, only for my all lawyers who are also sharing dice with us. Why mediation is not going acceptable to the parties in our country here? Why questions are being raised? My experience of 2 years of working is raised for two reasons. First, that the process of mediation has gone like a civil court. The mediations award is become the first court adjudication, either by the civil court or whichever the court have a jurisdiction. Then go to the first tier is 34, then go to second tier is 37, then go to Supreme Court, then review, then curative, and then go for execution. So the time schedule which we are consuming in arbitration goes to the same facet as that of a regular civil court. I don't know what is wrong in system, but something is wrong somewhere. If you go to mediation, I first clarify, mediation can only be an institutional mediation. Private mediation, as Nikhil has said, my request is we should never have a private mediation. Private mediation will create lot of problems, lot of disharmony amongst the parties. And if we hold today any mediation between both of us as a private mediator, and if that mediator decides, because if it is institutional mediation, it is binding on us, whatever the things come forward. A private mediation is not binding on us. Tomorrow, the mediator will be casted with an allegation that because he has seen mediator talking to Nikhil or talking to Vivek at one point of time, who is a party representing before the mediator. So the entire system will come into question mark. So there should be only, my request is there should only be a institutional mediation, completely transparent, formats are there, and once it is incorporated in the agreement, it's binding on you. You can't adopt any other mechanism for adjudication unless you go through the process of mediation as compulsion. But if you don't incorporate in the agreement, then a private mediation can be there and it always fails. Our country has not get success of mediation for these good reasons. I'll tell you one thing. If you have gone through the judgment of 2010 EFCON judgment, Justice Ravindran is the author of that judgment. And if I still recollect, because we cited that judgment, there are 31 or 30 are the two paragraphs where he has come across giving distinction between mediation. But I'm sorry to say, from 2010 and we are in 2025, 15 years, no one has followed those principles so far. And in 23 Mediation Act, are looking forward. Who can be a mediator? Who will regulate the conduct of mediation? Mediation council still has not been formed. And if you see the persons who can be chairperson of Mediation Council of India or the members, please see to it. You don't find, it's a never-ending system. Both ends open. The government can appoint any Tom, Dick and Harry as chairperson. Government can appoint any Tom, Dick and Harry as a member of the Mediation Council of India. If the foundation itself is not strong, if the foundation itself is not acceptable to the people, if the foundation is not commensurating with the need and requirement and demand of the people at large today, what kind of a system we are following? So harping on fee, to my view is, let us first strengthen the system of mediation under the Mediation Council or the Mediation Act of 23, and some prescribed fee in the manner which is acceptable to the parties, legislated by law or by any center, can be followed. That is the only way by which mediation can function. Otherwise, it is not going to function at all. And I give my illustrations to you. I had an impression earlier that private sector undertakings will never come for mediation to resolve because of the fact that they can't take anything on their shoulders. If some competent authority may take a call and decide and say, yes, my litigant commercial dispute, this claimant is entitled to this much of amount. God knows after 10 years down the line, who can question his integrity about the acceptability of that particular transaction. But I find that POCs are also coming forward. And I have two matters with me, where when I requested them, they are now under the process to settle through mediation. And when the matter was taken up by me after 1 month, they said, sir, give us more time. The senior authorities of the PSUs said, give us more time and we'll resolve. We don't want to trouble you. Things may come forward, but we have to strengthen this mediation business in our country to promote and better relations, commercial relations. Otherwise, the system, if we will not come forward, all of us, to join hands together, and if we go on harping on fee and fee all the time, the system will fail. So my endeavor and request is, please strengthen the institution first. Don't step to the fee. Fee will be decided by the government at a later point of time. And we will find the richness in working, acceptability by the parties, and expeditious disposal of claims pending before various courts. Because mediation once decided, no appeal, no revision, no Supreme Court, no curative.
Yes.
And curative business create more problems for the people. Thank you.
That's thank you for that intervention. Advocate Karthik said, I want to know from you this Justice Tejas Karia's idea that for this commercial disputes, we revise the fees, we sort of get in more people to actually do mediation rather than ticking that box and moving to litigate.
Yeah.
Do you think some quick steps like getting in a fresh fee schedule would change things quickly?
And there are only one thing. Nikhil has said, or Karthik has said about no fee if mediation is unsuccessful or fee if successful. My request is very damaging. Fee is not commensurate even with success or unsuccess. Fee is in reference to the efforts which has been put in by a mediator in resolving the dispute. So fee is not commensurating with success or unsuccess of the mediation.
Yes.
So
Point well taken, sir. Over to you, Karthik.
Yeah. So basically, what is falling from you is with regard to Justice Karia. So I'll just point out one thing. I mean, like, because we've all been in practice. I mean, like, apart from obviously Justice Rastogi for around 15 years or more, we have seen Justice Karia as a arbitrator. As a practicing arbitral lawyer, and I mean, if not the most successful arbitration lawyer he was in Delhi, he was one of the most, one of the best in any case. So coming from someone like Justice Karia, who had such a thriving practice specifically in arbitration, I mean, more than the litigation in courts, it was more than that. It was more about arbitration, where he had such a thriving practice.
Correct.
Coming from him, something like this is definitely coming out of experience of arbitration per se, and why he thinks that the fee schedule or anything like that follows into mediation as well. So, firstly, coming from a person like him who has had the experience purely in arbitration or mediation to a way larger extent is something which needs to be taken seriously, and there has to be a solid basis for it. My second point is with regard to what Justice Rastogi just now pointed out with regard to public sector undertakings and other things. There were two functions which has happened in this year itself. One which I recollect is Mr. G.L. Sanghi's memorial lecture, where the topic of his memorial lecture
Yes.
was mediation per se, mediation as a tool for 2030. And then there was another mediation conference which was organized by the Attorney General of India, where the President of India had graced the occasion, where he had focused specifically on mediation per se. I had the privilege of attending both of them. And in the first one, when it was the memorial lecture, the keynote address was given by Justice Sikri. There was Justice Manmohan and Mr. Mukul Rohgi speaking in that particular function. I very well remember Justice Sikri specifically pointing out that the public sector undertakings and the government of India everyone is aware is the biggest
Correct.
litigator or biggest like player in the market when it comes to litigation, mediation, or arbitration. They should have a specific clause for a pre-litigation mediation, which should be introduced in each and every clause. I mean, each and every agreement, each and every contract, which will be really helpful in the long run. Apart from, see, in Rajasthan, I'll tell you, we practice in the commercial court side. There is a pre-mediation clause under section 12A under the commercial courts act, where you have to go for a pre-mediation. I mean, pre-litigation mediation. In the similar manner, if there are clauses in the under the PSUs under this, it will really be helpful. And then Mr. Mukul Rohgi mentioned, Justice Manmohan mentioned on the same way, that mediation is something which in by 2030 will have serious mediators who are full-time mediators. Now, slowly and gradually, we are moving towards. I mean, Justice Rastogi, I mean, is. I mean, in a few arbitrations, I'm like before him. So there are times when we are not able to find dates of the arbitrators or of the lawyers who are doing litigation and the arbitration as well. So we need serial mediators who will solely focus their domain only into mediation, just like they will do it in arbitration per se. I think these things and then streamlining the fee schedule will really help in the long run.
Thank you for bringing in that aspect, Advocate Karthik said. I'll go to Advocate Nikhil Rohatgi for his intervention on Justice Tejas Karia.
Well, what I would say is that I don't think there's any gainsaying that this schedule of fees must be fixed. I think we all agree on that. All and sundry agree on that. That should definitely be fixed. I would just I would just like to say, rather tongue in cheek, that Justice Rastogi ha, has been a true public servant for this country, as a judge of this country, dispensing justice, and for great men like him, you know, the pleasure of doing your duty and the pleasure of doing your job and helping people is enough. But sadly, for many other people, that's not enough. That's the unfortunate truth. Now, so therefore, I feel that it's about attracting the best talent. It's the same reason why an accused might not want to have a panel appointed lawyer from the Delhi High Court, but he might want to go to the best in the country and pay lakhs per hearing. You're just simply not going to get the same talent as you would if private practice of mediation is possible. And in private practice, I firmly believe you should let the market forces dictate. You fix your fee. If the client is not okay with it, then he won't come to you. It's as simple as that. And with regard to the success fee, I actually must confess that I have my own dilemma on that. I'm myself not sure if there should be a success or a failure fee. But in this case, it's more, and I see the argument that yes, if a lawyer or a mediator has put in his hard work, then he must be compensated for it, irrespective of the outcome. But in this case, there's a slight twist to it, which is that in mediation, unlike in arbitration or in litigation, either of the parties can opt out at any time. Yes, if they have to go for mediation, like under 12A of the Commercial Courts Act, then they have to go for it. But if their heart is not in it, then they can opt out at the first session. So if the parties know, in some cases, the argument is that if they know that they will only have to pay this fee if they succeed, if the mediation is successful, if they arrive at a settlement, then that may help them to stay invested in the process of mediation. Otherwise, they can simply opt out of it, which is not an option in arbitration or in litigation. The other thing I would like to agree, of course, with Justice Rastogi is that in some way, what he was, I think, driving at is that to make the structure and the foundation of mediation stronger. Now, unlike other independent statutory bodies, such as the Indian Council of Chartered Accountants, the ICAI, which is also set up by a parliamentary act. In this act, under Section 53, all the regulations, rules, guidelines, requirements, schedules fixed by the council, which is yet to be set up, but when it is set up, everything has to be laid before Parliament and approved by Parliament. So not only does this, introduce government interference and government control, which there should not be. I think it should be a purely independent body, but it also makes things that much longer because we know how long all that red tape takes. And lastly, I'd like to say that it's very encouraging that, as Justice Rastogi said, that even state and central government PSUs, by virtue of Section 49 of the Act, it makes it clear that they can also arrive at a settlement by mediation for commercial disputes, except that they have to then, I think they have to get it approved from their higher authorities before consenting to that mediation. So, yeah, those are my points. Wholeheartedly agree in the end with what Justice Karia said.
Thank you for that intervention, Advocate Vivek Jain. What do you have to opine about what Justice Tejas Karia has said?
Well, I think Justice Karia and Justice Rastogi has a unique distinction and a unique position to have seen the disputes both ways, as a lawyer appearing for the parties and also as judges judging the matter. And if after that kind of an experience, both these distinguished people and jurists are saying that mediation is the way going forward, then there is some substance to it. I won't say some would be underrated, but there is a great substance to it. Now, there is also a very important point which Justice Rastogi has made, that though you term arbitration as alternate dispute resolution, but you have the same hierarchy of appeals after appeals in the arbitration. Now, how is it an alternate to a civil dispute? In a civil dispute, you have an appeal. In arbitration, you have 34. After that, you have a second appeal. You have section 37. Then 136 is available to everybody. So therefore, I think, the whole point is, according to me, mediation has to be institutionalized. That's number one. And why it needs to be institutionalized is also to give finality to mediation. Because if you don't give finality, if you are not able to give finality to mediation, then you would again fall into the trap of ADR where there are appeals which are there and the matter will drag on into the court. So therefore, I think there is a need to institutionalize it. And therefore, once you institutionalize it, then therefore there is an opportunity for you to create pillars for that institution to prosper. And those pillars would be the mediators. Now, how would you strengthen those pillars? You can only strengthen it by giving confidence to those pillars, by actually increasing and making it commensurate with their hard work. So, according to me, it's a very well thought out statement which is made. And therefore, I have thought about it and reasoned it. That's the only way, if you think about it deeply, that's the only way to go about it. Now, we are talking about PSUs. Now, I have seen a lot of matters getting settled under Vishwas scheme. Now, why can't that happen before 34 stage? Because that Vishwas scheme comes only if you are an award creditor and then you try to settle with PSUs. And there are a lot of matters which I have settled, where it has got settled. People have taken haircuts and they've settled. After litigating for 10 years, they've realized that I have to again litigate for 10 more years. And they settled it. So this Vishwas actually has to be shown to the mediation as, according to me, it's a need of an hour. And coming from two distinguished jurists, I wholeheartedly welcome it and actually endorse it. And that was my view.
Thank you, Vivek.
I'll tell you one thing.
Yes.
When you talk about fee for the mediator, sometimes we start proportionately examining the fee charged by the lawyer appearing for the party. My request is always one. There is no comparison of the fee which a professional charges for the client and the mediator or the arbitrator charges for the kind of an adjudication. There is no comparison, and we should not compare. Lawyer is on demand. Party wants XYZ lawyer. So he's on demand, and whosoever can afford, they will go to fulfill the demand of the lawyer because of his professional skill. Like mediators or arbitrators, you say he shall be the arbitrator. Parties don't have a choice. You only have a different categories that because of conflict of interest, this arbitrator or this mediator or this judge can't hear the matter. But rest he has to. Parties can't say sorry, I don't want this mediator or this arbitrator unless he falls within the category of exceptions. So this has to be kept in mind when you are a mediator or an arbitrator, that your fee in no manner can commensurate with the fee the lawyer charges for the litigants. And when I think forward that such and such lawyer is charging so much, why can't I get it? I'm myself, I can say for myself, I'm mistaken. It's an adjudicating process. You're being called upon to adjudicate and decide the dispute or the list between the parties. And the professional skill of a lawyer, I can tell you, with my experience of a professional lawyer, it's very, very difficult. The kind of intricacies, the kind of a depth, the kind of a time, the kind of knowledge, the kind of confidence, or unless all these things commensurate together, then only you can be a good professional. But these qualities are not required for an arbitrator or for a judge or for a mediator. So everybody is being paid according to the commensurate of the value which you put in a litigation. So no comparison. So I conclude myself.
So you are saying that the fees should be better than what it is today, but don't compare it to an arguing counsel in Supreme Court.
Yes. No
Okay.
comparison with the concept.
It's a fair point. It's a fair point. Thank you for that putting thought to the statement that Justice Tejas Karia shared with us. As the other panelists also mentioned, he's one of our most respected professionals in the ADR field, who chose this career in the judiciary. We are thankful because we need judges like Justice Tejas Karia. I would like to thank you, Justice Ajay Rastogi. We all know that you are now doing a lot of arbitrations, and if the mediation fees works out, then why not Supreme Court appointed mediations as mediator? That is the future also. And I hope somebody is listening, so you get appointed at least, so that we can sort of ask you about
it. Find my name. I don't say Justice Rastogi. I said now after my term is over, I'm not Justice Ajay Rastogi. I'm Ajay Rastogi.
No, but for us, you continue to be Justice.
Sir, for us, you are always Justice Ajay Rastogi.
No.
That will never change.
So nice.
Then
I'm Ajay Rastogi. Then rather than Justice Ajay Rastogi, my Justice Ajay Rastogi, I deputed office and gone. No, I'm not a judge. I can be an arbitrator. I can be a mediator, but not a judge.
Right.
But cannot go.
Yeah.
Thank you.
Thank you. And Advocate Karthik Seth, Advocate Nikhil Rohadgi, Advocate Vivek Jain, who joined us at a short notice. Appreciate your joining us and putting in your insights on Justice Tejas Karia's idea. We hope that we see something positive very soon in the future. And knowing how persistent Justice Tejas Karia is, I'm very hopeful. Thank you so very much. Thank you.
Thank you.
Thanks a lot.
Thank you, Tarun. Thank you, everyone.
All young man.
Everyone.
Thank you, sir.
My
Thank you.
pleasure to join all young people of.
Thank you.
You are the youngest amongst us.
It's our privilege, sir.
For more such videos, subscribe to the Newsx YouTube channel, hit the bell icon.